Please be seated.
The sitting is open. Before we start our judicial proceedings today, I would first like to pay solemn tribute to the memory of Judge Stephen Schwebel, our esteemed former colleague, who sadly passed away on the 9th of April. The late Judge Schwebel was a member of the court from 1981 until 2000, and he was elected by his peers as Vice President from 1994 to 1996, and as President from 1997 to 2000. Born in 1929 in New York, Judge Schwebel received a BA with highest honors in government from Harvard University, and then chose to focus his studies on international law, first at Cambridge University, and then at Yale Law School, where he received an LLB. During his long and illustrious professional life, Judge Schwebel combined legal careers as a practitioner, an academic, a legal advisor to his government, a judge, and arbitrator. In 1959, he was appointed assistant professor at Harvard Law School, where he founded what later became the Jessup competition, where hundreds of universities around the planet participate every year. He then became the Buring Professor of International Law at Johns Hopkins School of Advanced International Studies. In the 1960s and 70s, he served as the U.S. State Department in various capacities, including as Assistant Legal Advisor and Deputy Legal Advisor. In parallel, from 1977 to 1981, he was a member of the International Law Commission. Judge Schwebel thus arrived at the Peace Palace in 1981 with a wealth of valuable experience, which he translated into a rigorous intellectual approach to the court's judicial deliberations, without ever overlooking the importance of maintaining a grounded appreciation of the practical effects of the court's rulings. By his own account, he had followed the creation and development of the United Nations with great enthusiasm, and thus relished the opportunity to put himself at the service of the principal judicial organ of the United Nations. During his 2 mandates, Judge Schwebel was extremely active in the judicial work of the court, in particular overseeing plenary meetings and drafting committee sessions in his capacity as president. As a judge, he was involved in the adjudication of 38 cases, covering a range of complex and often profoundly far-reaching questions of international law. While he fervently believed that the strengths of the court lay in the collective nature of its deliberations, Judge Schwebel nonetheless remained a fiercely independent thinker. It was not uncommon for him to dissent from the majority view, and his persuasively crafted opinions and declarations continue to provide much food for thought for students, scholars, and practitioners. Judge Schwebel left an indelible mark in terms of the general administration of the court, thanks to various significant innovations he launched to improve the working condition of the institution. In that regard, in the 1990s, he was instrumental in negotiating with the host country an extension to the judges' wing of the Peace Palace in order to accommodate the increased number of ad hoc judges and to create a dining facility for judges for the first time. Just prior to his departure from the court, he also spearheaded the initiative
to establish the university trainee program with the New York University, which later became the Judicial Fellowship Program and now involves recent law graduates from all over the world. Following his retirement from the court, Judge Schwebel channeled his indefatigable energy into international arbitration work. During the 2000s, he served as an arbitrator in various cases administered by the Permanent Court of Arbitration. He was also appointed as an arbitrator on various exit panels dealing with investment disputes, and was a member of the Administrative Tribunal of the World Bank. In addition, he published widely on many topics of international law and was the recipient of numerous prestigious awards and honors. Throughout his life, Judge Schwebel dedicated himself to international law and justice with unwavering commitment and integrity. He will be remembered as an exemplary judge who was greatly respected by his peers for his brilliant legal mind and his charming disposition. We extend our deepest sympathy to his family at this sad time. I would now like to invite you to stand and observe a minute's silence in memory of Judge Stefan Schwebel. Thank you very much. Please be seated. I shall now turn to the judicial proceedings before the court. The court meets today and in the coming days to hear the oral arguments of the parties on the merits in the case concerning the Arbitral Award of the 3rd October 1899, Guyana versus Venezuela. For reasons duly made known to me, Judge Bandari is unable to participate in these proceedings, and Judge Abraham is unable to sit with us today. I note that in addition to interpretation from and into the court's two official languages, English and French, interpretation from and into Spanish is available in accordance with the specific arrangement made at the request of Venezuela. Since the court included upon the bench no judge of the nationality of either party, each party proceeded to exercise the right conferred upon it by Article 31, Paragraph 3 of the statute to choose a judge ad hoc to sit in the case. Guyana first chose Ms. Hilary Charlesworth. Following Ms. Charlesworth's election as a member of the court, Guyana chose Mr. Rudiger Wolfram. Judge Charlesworth subsequently indicated that, in the circumstances, she had decided no longer to take part in the decision of the case. Venezuela chose Mr. Philippe Couvreur to sit as a judge ad hoc in the case. Mr. Wolfram and Mr. Couvreur were duly installed as judges ad hoc on the 17th of November 2022, during the phase of the present case that was devoted to the preliminary objections raised by Venezuela. I shall now recall the principal steps in the procedure in the present case. On the 29th of March 2018, Guyana filed in the registry of the court an application instituting proceedings against Venezuela with respect to a dispute concerning, I quote, the legal validity and binding effect of the award regarding the boundary between the colony of British Guyana and the United States of Venezuela of the 3rd October 1899. End of quote. to which I shall refer as the 1899 Award, or the award. To found the jurisdiction of the court, Guyana invoked Article 36, Paragraph 1 of the Statute of the Court and Article 4, Paragraph 2 of the agreement to resolve the controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana, signed at Geneva on the 17th of February, 1966, to which I shall refer as the Geneva Agreement. Pursuant to Article 4, Paragraph 2 of the Geneva Agreement, the Secretary General of the United Nations decided on the 30th of January 2018 to choose judicial settlement by the court as the means of settlement of the controversy. By an order of the 19th of June 2018, having been informed that the Venezuelan government considered that the court manifestly lacked jurisdiction and that Venezuela had decided not to take part in the proceedings, the court decided that it was necessary, first of all, to resolve the question of its jurisdiction. Following the filing of a memorial by Guyana on the question of jurisdiction and the submission by Venezuela of a document titled Memorandum of Bolivian Republic Venezuela on the application filed before the International Court of Justice by the Cooperative Republic of Guyana on March 29, 2018, a public hearing was held on the 30th of June 2020 on the question of jurisdiction, in which Venezuela did not participate. In its judgment of the 18th of December 2020, the court found that it had jurisdiction to entertain the application filed by Guyana, insofar as it concerns the validity of the 1899 award and the related question of the definitive settlement of the land boundary dispute between Guyana and Venezuela. By an order of the 8th of March 2021, the court fixed the 8th of March 2022 and 8th of March 2023 as the respective time limits for the filing of a memorial by Guyana and counter-memorial by Venezuela on the merits. Guyana filed its memorial within the time limit thus fixed. On the 7th of June 2022, Venezuela raised preliminary objections to the admissibility of the application with reference to Article 79 bis of the Rules of Court. Consequently, by an order of the 13th of June 2022, the court fixed the 7th of October 2022 as the time limit within which Guyana could present a written statement of its observations and submissions on the preliminary objections raised by Venezuela. Guyana filed its written statement on the 22nd of July 2022. Hearings on Venezuela's preliminary objections were held from the 17th to 22nd November 2022. By a judgment dated the 6th of April 2023, the court, which understood Venezuela to be making in substance only a single preliminary objection, rejected that objection and found that it could adjudicate upon the merits of the claims of Guyana insofar as they fell within the scope of its competence according to the 2020 judgment. By an order of the 6th of April 2023, the court fixed the 8th of April 2024 as the new time limit for the filing of the counter-memorial of Venezuela. On the 30th of October 2023, Guyana filed a request for the indication of provisional measures. By an order of the 1st of December 2023, the court, having heard the parties, indicated two provisional measures, one addressed to Venezuela and the other addressed to both parties. On the 8th of April 2024, Venezuela filed its counter-memorial within the time limit fixed by the court. By an order of the 14th of June 2024, the court authorized the submission of a reply by Guyana and a rejoinder by Venezuela, and fixed the 9th of December 2024 and the 11th of August 2025 as the respective time limits for the filing of those written pleadings. The reply was filed within the time limit prescribed. On the 6th of March 2025, Guyana filed a new request for the indication of provisional measures. By an order of the 1st of May 2025, the court, having heard the parties by means of a written procedure, reaffirmed the provisional measures indicated in its order of the 1st of December 2023 and indicated an additional provisional measure addressed to Venezuela. On the 11th of August 2025, Venezuela filed its rejoinder within the time limit fixed by the court, and the case thus became ready for hearing on the merits of the case. Pursuant to Article 53, Paragraph 2 of its rules, the court decided, after consulting the parties, that copies of the written pleadings and documents annexed would be made accessible to the public on the opening of the oral proceedings. Further, in accordance with the court's practice, these pleadings and documents annexed will be placed on the court's website from today. I would now like to welcome the eminent representatives of the Guyana and Venezuela who are in the Great Hall of Justice today. In particular, I note the presence of His Excellency Honorable Hugh Todd, Minister of Foreign Affairs and International Cooperation of Guyana, His Excellency Mr. Ivan Eduardo Pinto, Minister of Foreign Affairs of the Bolivian Republic of Venezuela, as well as the agent of Guyana and the agent of Venezuela, each accompanied by members of their respective states' delegation. In accordance with the arrangement on the organization of the proceedings, which have been decided by the court, the hearings will comprise a first and second round of oral argument. The first round of oral argument will begin today with the statements of Guyana and will close on the afternoon of Wednesday, the 6th of May, 2026, following Venezuela's first round of oral pleading. Each party has been allocated 2 sessions of 3 hours for the first round. The second round of oral argument will begin on the afternoon of Friday, the 8th of May, 2026, and conclude on the afternoon of Monday, the 11th of May, 2026. Each party will have a maximum of 3 hours to present its reply. In this first sitting, Guyana may, if required, avail itself of a short extension beyond 1 p.m. in view of the time taken up by my introductory remarks. I shall now give the floor to the Minister of Foreign Affairs of Guyana, His Excellency Honorable Hugh Todd. You have the floor, sir.
Mr. President, members of the court,
it is a singular honor to appear before you today on behalf of my country, the Cooperative Republic of Guyana. To open the proceedings in this matter is both a privilege and a solemn responsibility. This case has an existential quality for Guyana. At stake is more than 70% of our sovereign territory, which has been recognized to be an integral part of the country for more than 126 years, including the past 60 years since independence. The Essequibo, as this land is known in Guyana, is named for the Essequibo River,
the largest and most remarkable in Guyana, which runs through it. For the Guyanese people, it is tragic even to think about having our country dismembered by stripping from us a vast majority of our land, together with its people, its history, its traditions and customs, its resources and precious ecology. Guyana would no longer be Guyana without it, without them. It is for this reason, and because we are convinced of our rights and entitlement to the territory under international law, and in the fairness and scrupulous integrity of this court, that the President of Guyana, His Excellency President Mohamed Irfan Ali, has asked me, as Minister of Foreign Affairs and International Cooperation, to lead Guyana's delegation and to deliver the opening remarks. In Guyana's view, it is appropriate here in these circumstances to underscore the existential nature of this case for Guyana and the Guyanese people. Mr. President, members of the court, Guyana respectfully submits that this case is as straightforward as it is consequential. It is about title to territory. Almost 160,000 square kilometers of territory. That territory was recognized to be part of British Guyana, then a colony of Great Britain, by the award of a unanimous arbitral tribunal, consisting of 5 of the most eminent and highly respected jurists of that era, in October 1899. That award was a culmination of an exhaustive legal process which involved the submission of more than 5,000 pages of written arguments and documentary evidence, followed by a hearing that lasted more than 3 months, and which involved more than 200 hours of oral submissions by distinguished legal counsel and 54 sessions of 4 hours each. All of this was in conformity with the terms of the prior written compromise, executed in the form of a treaty, the Treaty of Washington, in 1897. The case is also about Venezuela's total and unreserved acceptance of that award, not least by the agreement of 1905, which faithfully implemented the boundary determined by the tribunal. For 6 decades, Venezuela fully respected and complied with that award and that agreement. Throughout that period, it never protested or challenged the award or the agreement. In fact, established and uncontested that Venezuela consistently respected the award and the agreement in practice, and that the boundary established by the award and the agreement were consistently reflected in Venezuela's official acts, maps, legislation, and international agreements until at least 1962. Mr. President, members of the court, it is Guyana's submission that the 1899 award is without question legally valid and binding on the parties, and that the 1905 boundary agreement is legally valid and binding on the parties. It is Guyana's submission that none of the arguments Venezuela has raised prior and during these proceedings against the award or the agreement has any merit whatsoever, and that Venezuela's challenges to the award and the agreement are in any event decades, no, a century too late to be raised as a matter of international law. The inevitable consequence is that the international boundary described in the 1899 award and demarcated in the 1905 agreement is, in fact, and has for more than a century been the lawful border between Guyana and Venezuela. Venezuela is obligated under international law to accept and respect that border and to refrain from any activities that infringe on the territory across that border, which constitutes Guyana's sovereign territory. This is a historic moment. This is a moment of truth for Guyana and for Venezuela. For more than 8 years have passed since Guyana filed its application commencing these proceedings. We have now arrived at the final stage. The oral hearings on the merits, after which the court will deliberate and issue its judgment on the validity of the 1899 award and the course of the international boundary between Guyana and Venezuela. We have arrived at this historic moment, despite Venezuela's persistent efforts to stop us from getting here. First, it objected to the court's jurisdiction based on a strained and untenable reading of the 1966 Geneva Agreement, which the court soundly rejected in its judgment of 18 December 2020. Then it objected to the admissibility of Guyana's claims. The court again resolutely rejected this effort in its judgment of 6th of April 2023. Unable to derail the case, Venezuela decided to take matters into its own hands. In late 2023, it purported to stage a so-called national referendum seeking popular support for rejecting the jurisdiction of the court and disassociating itself in advance from any judgment the court might issue on the merits of the case. The referendum called for the endorsement of Venezuela's assertion of sovereignty over the Essequibo and planned to formally incorporate it into Venezuela. On 1st of December 2023, the court, acting on Guyana's request, indicated provisional measures prohibiting Venezuela from taking any of these steps pending the final judgment in the case. Venezuela proceeded to do exactly what the court ordered it not to do. It issued executive decrees, followed by national legislation rejecting the court's jurisdiction, including any judgment that might be forthcoming, and formally incorporating the Essequibo into Venezuela. Last year, after Venezuela announced that it would hold elections in Essequibo to choose a governor and legislative assembly for the territory, the court issued another provisional measures order prohibiting that intended activity. Mr. President, members of the court, Guyana is extremely grateful for the actions the court has taken thus far. Upholding its jurisdiction for Guyana's application, upholding the admissibility of Guyana's claims, and issuing provisional measures orders to preserve the rights claimed by Guyana that are at issue in this case. We know that these rulings were based on the court's faithful application of international law, nothing more and nothing less, but we are grateful nonetheless. Notwithstanding these actions, Guyana has suffered and continues to suffer greatly from Venezuela's unlawful claim to threats to the majority of our territory. This has been a blight on our existence as a sovereign state from the very beginning of our existence. It has been a threat to our peace and security, exacerbated in recent years by the ominous growth of Venezuela's military activities, construction of new bases, new airfields, and its deployment of aircraft, heavy weapons, and troops to the border area. Venezuela's intentions are unmistakable, as revealed in the executive decrees and national legislation to which I referred, the acquisition of our territory and its incorporation into Venezuela. Facing a larger and more powerful neighbor's designs on our territory has not only threatened our peace and security, it has held back our development. To be sure, the international community supports Guyana's sovereignty and territorial integrity, including its title to all of the territory east of the international boundary, as defined in the 1899 award and the 1905 agreement. But economic development has been slowed by Venezuela's claims and its threats. Foreign investors in particular have been reluctant to risk their capital in such circumstances, and far too little investment has been the consequence. For Guyana, which acceded to the 1966 Geneva Agreement upon its independence, it has taken 60 years to reach this climatic moment and to be in a position to obtain a final, definitive, and binding judgment from the world's most highest judicial authority on the validity and permanence of the 1899 Arbitral Award and the boundary that it established. My predecessors scrupulously followed the processes mandated by the 1966 agreement and exhausted all of them, until in January 2018, the Secretary General, acting pursuant to his authority under Article 4.2 of the agreement, decided that the controversy over the validity of the 1899 award should be resolved by this honorable court. Sadly, not all of the Guyanese statesmen and stateswomen who were instrumental in bringing us to this point have survived to bear witness. As a Guyanese and as head of our delegation, I would be remiss if I did not honor two of them this morning. First, our first agent was a truly towering figure, internationally as well as in Guyana. Our friend and mentor, Sir Sridhar Ramphal. After serving as Foreign Minister and Attorney General of Guyana, became the Secretary General of the Commonwealth, where, among other contributions, he worked long and hard for the freedom of Nelson Mandela. Less well known to you, but equally beloved in Guyana and the diplomatic community that she enriched, Ambassador Elizabeth Harper. The heart and soul of the Guyana's delegations to the court in earlier oral proceedings sadly passed away in September 2025. It is in their honor, as well as in the name of the entire Guyanese people, of past, present, and the future generations, that we carry on this struggle for Guyana's sovereignty and territorial integrity based on the rule of international law. Mr. President, members of the court, Guyana is privileged to be represented by a team of highly experienced and outstanding international lawyers, from whom you will hear today and again on Friday. Our next speaker who will follow me to the podium is Professor Pierre D'Argent. He will respond to Venezuela's ongoing objections to the court's jurisdiction, which consume more than half of its rejoinder, its final written pleading, and which Professor D'Argent will demonstrate and reflect a gross misleading and misinterpretation of the 1966 Geneva Agreement. We will then turn to from jurisdiction to the merits. To introduce that part of the case, two of my fellow Guyanese will make brief presentations. First, Ambassador Donna Street of the Foreign Ministry will introduce you to the territory that underlies this controversy, focusing on its geography and its human and natural resources. And then Guyana's agent, Mr. Carl Greenidge, a former Minister of Foreign Affairs, will speak on the history of the territory and the dispute between Great Britain and Venezuela, leading to the 1897 treaty that provided for arbitration of the territorial dispute between the two states. Mr. Greenidge will be followed by Mr. Paul Reichler, who will address you on the 1897 treaty itself. Venezuela claims that the 1899 award is invalid based inter alia on the invalidity of the 1897 treaty. Mr. Reichler will demonstrate that Venezuela's arguments have no merit, and that the 1897 treaty was a valid treaty and agreement to arbitrate the territorial dispute. In the afternoon session, Professor Alain Pellet will address and refute Venezuela's other arguments challenging the lawfulness of the 1899 Arbitral Award. He will be followed by Professor Nilofer Oral, who will describe Venezuela's acceptance, respect, and the compliance with the 1899 award, as well as its failure to protest for over 60 years and the legal consequences to be drawn from such acquiescence. Professor Philip Sands, King's Counsel, who will demonstrate that the so-called Malay Proverb memorandum, which appeared in 1949 and 13 years later, Venezuela invoked as grounds for nullifying the 1899 award. Provides no basis for calling the award into question on any grounds. Guyana's final speaker will be Mr. Edward Craven, King's Counsel, who will address Guyana's breaches to the court's 2 orders on provisional measures and Guyana's submissions regarding the validity of the 1899 award. In closing, I would like to emphasize that Guyana places its fullest confidence in this court, with no doubt that whatever the court ultimately decides, it will be a fair and just result, based entirely on the evidence before it and the even-handed application of international law. As we have done previously, Guyana reiterates its pledge to honor and comply with the court's judgment, whatever it may be, as it is bound to do in any event by the United Nations Charter and the statute of the court. Guyana hopes that Venezuela would make the same pledge. Mr. President, members of the court, I thank you for giving me the honor to appear before you and for your generous indulgence in listening to my remarks. I ask you to please invite Professor Dargent to the podium.
I thank His Excellency for his statement. Je donne maintenant la parole au professeur Pierre Dargent. Monsieur.
I now give the floor to Professor Pierre Dargent. Sir, you have the floor. Thank you, President, members of the court. It's an honor for me to take the floor before you this morning on behalf of the Cooperative Republic of Guyana. As you have no doubt observed, and as His Excellency, the Minister of Foreign Affairs, has just explained, over half of Venezuela's rejoinder focuses on the Geneva Agreement. Venezuela contends that, in view of its content and effect, but in a way which remains largely unexplained, the Geneva Agreement would render moot the jurisdiction which the court declared it possessed in its 2020 judgment, and which it also declared it was able to exercise in the 2023 judgment. These arguments are not new in any way and have already been rejected by the court. However, because Venezuela's pleadings are lengthy, pointlessly controversial and confusing, Guyana deemed it necessary to answer them briefly. This is my task in view of your judgments, which have res judicata effect and which Venezuela persists in defying in disregard of its obligations under the Charter and Statute. As the court's composition has greatly changed since the judgment of the 18th of December 2020, Venezuela is maybe thinking, and very strangely, that it has nothing to lose. The attempt is to no avail, in addition to being devoid of legal merit. The composition of the court, nonetheless, for me, is a reason to ask for your indulgence for a pleading which in reality is not called for. Mr. President, before answering the arguments put forward by Venezuela in its rejoinder, We need to dwell a moment on the underlying reasons which explain why, although it finally has an opportunity to secure a victory for its legal arguments before the court, the respondent is doing everything in trying to avoid it making a pronouncement. This paradoxical situation can simply be explained by the trap which Venezuela set for itself and in which it has been trapped for over 60 years. Presenting the Geneva Agreement to the National Congress in March 1966, the Venezuelan Minister of Foreign Affairs had stressed, indeed, that this agreement would require Venezuela to put all its strength into action to consolidate its claim with serious and detailed studies. The exhortation made by the Minister Iribarren Borges is no doubt the most striking acknowledgement that the claim of invalidity of the 1899 award was made without any serious and detailed studies. This claim of invalidity was thus made instinctively, emotionally, and thoughtlessly, except with regard to its timing, when Guyana's independence was in view. As my colleagues will demonstrate, during the 60 years which have lapsed since the Geneva Agreement, Venezuela has failed to find a more solid basis for its claim. However, once filed and conveyed to all echelons of society, this claim has become an article of faith, which no Venezuelan politician can repudiate without immediately being seen as a traitor to their country. After so many years, what counts now for Venezuela is, as the heading of its written statements shows, for its truth to survive and not to be contradicted by a judgment of the court laying bare this ill-founded and misleading narrative. Yet, members of the court, yet, in substance, this is the task that falls to you. Venezuela's arguments regarding the Geneva Agreement are therefore merely intended once again to postpone this moment of truth. After 60 years, this moment, however, has arrived, and nothing which the court has already said with regard to its jurisdiction and its exercise can be called into question by these arguments. Mr. President, for the clarity of the debates, I would like to deal with Venezuela's arguments following the order in which they're presented in the rejoinder itself. I'll start, therefore, by explaining that Guyana was well-founded in not dwelling in detail on the Geneva Agreement in its reply. After that, I shall show that the interpretation of the Geneva Agreement presented by Venezuela is erroneous and has already been adjudicated as such by the court. I will then examine the argument relating to decolonization and the argument on legal novation recently introduced by Venezuela. These arguments don't add anything to the debate, but well understood, and as I will demonstrate, they allow in reality to substantiate and not disprove the conclusions which the court reached in 2020 and 23, and which, and this will be my last point, which in all respects are res judicata for the parties and for the court. Mr. President, in the first chapter of its rejoinder, Venezuela blames Guyana of deliberately ignoring the Geneva Agreement in its reply. The reproach, of course, is uncalled for, inasmuch as the reply dwells on the merits, and it was submitted after the judgments of 2020 and 2023. In its 2018 memorial on questions of jurisdiction, Guyana explained its position on the Geneva Agreement, and once again, during the hearings of June 2020, which Venezuela decided not to take part in, and which resulted in the judgment of the 18th of December 2020, And yet again, during the phase relating to the preliminary objection raised by Venezuela in June 2022, the written and oral communications of the parties focused once again on the Geneva Agreement, just like the judgment of the 6th of April itself. And it's because Venezuela does not accept the judgments of 2020 and 2023 that it is accusing Guyana of not dwelling on the Geneva Agreement in its reply, although its meaning and scope were considered and determined in those judgments. The first chapter of the rejoinder is therefore an opportunity for Venezuela to try to convince the court that the Geneva Agreement allegedly is not what it very clearly said it was. And I would like to read out paragraph 66 of your 2020 judgment. The controversy that the parties agreed to settle through the mechanism established under the Geneva Agreement concerns the question of the validity of the 1899 award, as well as its legal implications for the boundary line between Guyana and Venezuela. End of quote. Yet the rejoinder maintains that the Geneva Agreement is purportedly, and I quote, much more than a mere procedural stepping stone. It is a substantive instrument designed to address a specific controversy and to provide a path towards a mutually acceptable practical solution. According to Venezuela, the Geneva Agreement purportedly settled the question of the award's validity, so that this question has become moot and therefore cannot be decided, with the consequence that the court would have no part to play because a mutually acceptable practical solution presupposes the agreement of the parties, whereas a judgment adjudicating in one way or another on the validity of the award would purportedly lead to a situation of imbalance between the parties. Mr. President, members of the court, it is clearly striking to observe that whilst claiming to seek a mutually acceptable and negotiated solution for a dispute which wouldn't be the one identified by the court, Venezuela in reality considers, as it already did in 1965 and continued to do so ne variator since then, that the only acceptable solution to its eyes is the one which would grant it what it deems to be its rights over the whole of the Essequibo region. Thus, it's no doubt because Venezuela is seeking a mutually acceptable solution through a negotiation that it unilaterally and illegally sought to annex the whole of the Essequibo at the end of a referendum and elections, which were the subject of orders indicating provisional measures. Through its unilateral contact and the fait accompli which it is seeking to impose in breach of the court's orders, we shall observe that Venezuela is contradicting its own understanding of the Geneva Agreement, a sign, no doubt, that its commitment to the latter, which it never fails to proclaim, is purely a formality and fictitious. The blame levelled against Guyana in the first chapter of the rejoinder therefore amounts to mere posturing and should not be heeded by the court in any way. However, Mr. President, it's in the first chapter of the rejoinder in paragraph 139 that we find the only attempt by Venezuela to explain how the court might decide not to exercise its jurisdiction, established nonetheless in the 2020 judgment, and to rule on the validity of the award. According to Venezuela, the preservation of the court's judicial function is at stake, similarly to what was decided in the Northern Cameroon case, although the two cases are very different. Indeed, in 1963, the court decided not to exercise its jurisdiction, as any judicial decision on the merits would be irrelevant, because, as Cameroon had acknowledged, a court's judgment could not have an effect on a General Assembly decision attaching Northern Cameroon to Nigeria in accordance with the results of the plebiscite supervised by the United Nations. Conversely, and in the instant case, a judicial decision deciding the question of the validity of the award would not fail to have a legal effect, to have some practical consequence on the very object of the dispute. To quote the court in the Northern Cameroon case, your future judgment will remove uncertainty from their legal relations. Now, of course, in the logic of Venezuela, such a decision is not allowed because the Geneva Agreement purportedly pursues another object. But once again, that is not what was decided by the court in 2020, such that relying on the Northern Cameroon case is erroneous, because it presupposes what it is attempting to obtain and what the court has already rejected. The first chapter of the rejoinder ends with a barely veiled threat towards the court, and I would like to quote the original in English. The court has no role to play in resolving the territorial dispute over the Guyana Essequibo. Any other approach would exacerbate the dispute. Mr. President, members of the court, it is difficult to read these words other than seeing them as a form of intimidation, as Venezuela is thus announcing in substance and shamelessly that it would itself exacerbate the dispute if it were decided by the court. Guyana does not doubt that the court will not be impressed by this argument, and that, faithful to its task, it will decide the dispute, which it has correctly identified, and it will maintain its jurisdiction. Mr. President, members of the court, the second chapter of the rejoinder, in fact, was intended to replace the 1899 Arbitral Award, on which they held fundamentally divergent and irreconcilable positions, with a new practical settlement, regardless of the award's legal status. Throughout its arguments, Venezuela thus claims, in essence, that through the Geneva Agreement, the United Kingdom and Guyana, failing an explicit recognition of the invalidity of the award, would have accepted to relinquish to its benefit, thereby seeking a mutually negotiated acceptable solution. Now, this attempt to rewrite the Geneva Agreement, whilst claiming it, is profoundly erroneous and totally at odds with the judgment for which the court has declared its jurisdiction. Indeed, the court has already adjudicated on this and rejected Venezuela's assertion, according to which the question of the validity of the 1899 award is not part of the controversy under the Geneva Agreement. This instrument, having purportedly been adopted based on the principle that the award is invalid and could not be discussed between the parties. As the court observed, the United Kingdom and Guyana have always considered that the assertion according to which the award was invalid was not justified, and that they accepted the Geneva Agreement only because it preserved the parties' positions in that respect. Looking at jurisdiction razioni materiae and confirming that the object of the dispute had been agreed according to the Geneva Agreement, the question of the validity of the 1899 award, as well as its legal implications for the boundary line between Guyana and Venezuela, the court underscored by using the expression the Venezuelan contention, expressed that the disagreement subsisted between the parties, and that solutions had to be sought according to the mechanism agreed in the agreement. As the court expressly stated, I quote, "This in no way implies that the United Kingdom or Guyana accepted the contention before or after the conclusion of the Geneva Agreement." Thus, the 2020 judgment adjudicated that the material jurisdiction of the court extended to the issue of the validity of the arbitral award, this question not having been made irrelevant nor replaced by the Geneva Agreement, and constituted, as the court pointed out, a necessary precondition for any final settlement of the boundary dispute. The court also stressed that Venezuela's argument that the Geneva Agreement does not cover the question of the validity of the 1899 award is contradicted by the statement of the Minister for Foreign Affairs of Venezuela before the Venezuelan National Congress shortly after the conclusion of the Geneva Agreement.
The court also pointed out, in particular, that the minister had declared that if the nullity of the award of 1899, be it through agreement between the concerned parties or through a decision by any competent international authority, as per agreement, is declared, then the question will go back to its original state. In addition to this, the ministerial address of 1966 clearly manifested at two other occasions, mentioned the purported nullity, which was the reason of the dispute with Venezuela, and that it should be settled and established through the Geneva Agreement. On the other hand, the minister believed that with the nullity of the award, Venezuela must consider out of question those territories, and on the other hand, express an opinion on the subject of Venezuelan territory likely to be claimed if the nullity of the award is declared. It is therefore beyond doubt that the question of the validity of the 1899 award was central to the controversy that needed to be resolved, to quote the 2020 judgment of this court. The arguments presented in the rejoinder were therefore already considered and rejected by the court, and it was certainly not necessary to examine them once again. May I note that, indeed, no judge, having voted against the first point of the dispositif of the 2020 judgment, considered that the question of the validity of the award had been set aside by the Geneva Agreement and therefore didn't fall within the scope of the dispute that they were intended to settle. Mr. President, the conclusion of the third chapter of the rejoinder argues, and I quote, that the Geneva Agreement, therefore, must be understood as a crucial step of decolonization, demonstrating a commitment to address colonial-era grievances and to seek a just and equitable solution to a territorial controversy that stemmed from the imbalances of the colonial period. Unquote. Venezuela further contends that even assuming that the award be valid, and I'm quoting the rejoinder in its English version, its territorial consequences could not be applied in absolute and unconditional terms in a dispute where the law of decolonization is the governing legal framework. Guyana does not dispute the existence of well-established principles of the law of decolonization highlighted in Venezuela's rejoinder, nor does it deny the numerous injustices stemming, even today, around the world from colonization and decolonization. However, it is doubtful that a state having declared its independence in 1811, a founding member of the UN, and that has never been a non-autonomous territory within the meaning of the Charter, that this state can be regarded as the subject and the beneficiary of the law of decolonization. Indeed, this law was developed at in the second half of the 20th century. Resolution 1514 of 14 December 1960 representing, as the court said, a defining moment in this regard. The law of decolonization was intended to free the then colonized people from colonial power, including colonial rule, including British Guyana. In any case, it is difficult to see what Venezuela is getting at by invoking the law of decolonization. If the point is to argue that the Washington Treaty or the Arbitral Awards are invalid because they resulted from coercion from a colonial power against a state that had been independent for almost 90 years and benefiting from the support of the largest power of the continent, Venezuela must prove this and not merely assert it. In its written statements, Guyana has already responded to these fallacious arguments belatedly put forward by Venezuela that it had been coerced into accepting the 1897 treaty. My colleague and friend, Mr. Reichler, will return to this point later on. Furthermore, if we are to argue, as Venezuela seems to do in the excerpt of the rejoinder that I just read in English, if we were to argue that Guyana was not entitled to succeed to the UK on the territory delimited by the award, even though it was valid, Venezuela would then have to provide proof of the existence of such an exception to one of the fundamental principles of the law of decolonization that the court only recently recalled. In such an unlikely legal assumption, or even if the award were to be null and void, it would also be up to Venezuela to prove that the boundary agreed in the 1905 treaty that confirmed the demarcation that was decided by the award had not acquired the permanence which the treaty itself does not necessarily enjoy. Instead of basing its claims on a rigorous legal analysis that specifically addresses the obstacles posed by international law, Venezuela merely invoked in a very general and opportunistic manner the law of decolonization, even though this is of no help to it, and that the true beneficiary of this law is Guyana, which was freed from colonial yoke in 1966. As to the rest, Guyana considers that the Geneva Agreement is a remarkable instrument of decolonization because it demonstrates the colonial power's acceptance of the possibility of challenging purported colonial injustices, provided that such injustices are duly established under applicable international law. And this is the very essence of the court's jurisdiction to examine the validity of the award. That the respondents should contest this jurisdiction while invoking the principles of decolonization is profoundly paradoxical. But at the same time, it also reveals that the respondent is indeed aware of the lack of legal basis for its claims. Furthermore, and as it appears from the 2023 judgment rejecting the objections based on monetary gold principles raised by Venezuela, colonial powers accepted through the Geneva Agreement that its conduct at the time could serve as a basis for the claim of nullity. Thus, far from putting Venezuela at a disadvantage, the Geneva Agreement, in fact, offered it the possibility to reopen the case of Guyana Essequibo, to quote the words of the Venezuelan president, Raul Leoni, at the time of its conclusion. The Geneva Agreement would become an instrument of decolonization, turning against decolonized Guyana if it had allowed its neighbor to maintain an exorbitant and unfounded claim indefinitely, hanging a sword of Damocles over nearly 3/4 of the territory inherited upon accession of independence. Mr. President, members of the court, the fourth chapter of the rejoinder presents the Geneva Agreement as an instrument of novation, as a novation, a mutually agreed substitution of the previous situation based on colonial domination for a new negotiated framework. According to Venezuela, concluding the Geneva Agreement, Venezuela, the UK, and the future state of Guyana agreed to a novatory process that precluded any later reliance on the null and void 1899 Arbitral Award. Under a new scholarly guise, drawing roots from Roman law and backed by decolonization law, the argument of novation resembles the one rejected by the court in 2020, but reiterated stubbornly in the rejoinder, and is based on the agreement that the Geneva Agreement settled the question of validity of the award once and for all. The argument of novation differs, however, by arguing that the Geneva Agreement would have fully replaced the former legal regime established by the award, and it necessarily presupposes that this regime had established obligations. Indeed, as Venezuela states, transformation constitutes the replacement of one set of obligations with another. The novation is thus the replacement of valid existing obligations with a set of other obligations. However, since Venezuela maintains that the sentence is invalid, its argument of novation is flawed. In fact, this argument presupposes what the respondent rejects. If the sentence is null and void, it cannot give rise to obligations, and if there are no obligations, there is no question of replacing them entirely with a new mandatory regime contained in the Geneva Agreement. The Venezuelan argument of novation, therefore, is afflicted by an insurmountable internal contradiction. If it was serious, the departure point of any argument of novation should accept that the award is valid and does create obligations, because in order to use the Permanent Court of International Justice's words, it is in the nature of a declaratory judgment, the intention of which is to ensure recognition of a situation at law once and for all, and with binding force as between the parties, so that the legal position thus established cannot again be called in question insofar as the legal effects ensuing therefrom are concerned. On that basis, Venezuela would have to demonstrate that the Geneva Agreement contains a consent, unequivocal and unambiguous consent to effect a novation, that is to say, replace a situation, a legal situation established by the award and which is binding, by another binding situation governing the same subject matter. But the Geneva Agreement had no such legal effect whatsoever. The effect of the Geneva Agreement is not to have recognized the nullity of the award, nor to have settled the matter, nor to have by itself replaced the obligations of the award by another legal regime, since it did not establish a new boundary. The sole effect of the Geneva Agreement was to allow a discussion on the subject of the validity of the award, and to have instituted a mechanism for this discussion to lead to a definitive settlement of the dispute arising from Venezuela's claim of nullity, resulting either in the confirmation of the validity of the award and thus the established legal situation through it, or on the declaration of the nullity of the award and therefore a new demarcation of the border between Guyana and Venezuela if the 1905 treaty and the frontier that it agreed were also and distinctly affected by it. In short, the Geneva Agreement cannot reasonably be interpreted as effecting a novation in whatever form. Mr. President, members of the Court, to conclude, I would say that there is no doubt that the first part of Venezuela's rejoinder seeks to challenge your 2020 and 2023 judgments. The respondent, in fact, makes no secret about this, as it rejects them. However, it never directly challenges the principle of res judicata, and it has not filed an application for a review under Article 61 of the statutes, which is the only procedure allowing the principle of res judicata to be challenged. It must be concluded, therefore, that Venezuela has not discovered any new fact of such a nature had it been known as to be a decisive factor on the conclusions reached by the court in its judgments of 2020 and 2023. And in these conditions, these judgments remain res judicata for the parties in the court itself. In the 2020 judgment, by referring to its jurisprudence, the court emphasized that a judgment on jurisdiction as on the merits is final and binding on the parties under Article 59 and 60 of the state statute. Consequently, depriving a litigant of the benefit of a judgment it has already obtained must in general be seen as a breach of the principles governing the legal settlement of disputes. In this case, all the arguments presented in the rejoinder are on points that have already been explicitly settled, either through or through logical implication, and that therefore fall under the res judicata effect. The standard utilized by the court to examine a question of jurisdiction at the merits stage is not whether to find if the arguments presented are new or if they recycle previously stated arguments, but if the decision on them would not contradict the finding of jurisdiction made in the earlier judgment. However, it is undeniable that if these contentions were retained, the contentions of the respondent in the reply would, therefore, if upheld, effectively reverse the 2020-2023 judgments. Guyana, therefore, respectfully requests the court not to deprive it of the benefits of those judgments and to proceed with the settlement of the dispute on the validity of the 1899 award. I would like to thank the court for its kind attention, and I would like to request the President to give the floor to Madam Ambassador Ms. Donnet Street to address the subject of the geographical context of the dispute. Thank you very much.
Je remercie le professeur Darjon. I now give the floor to Ambassador Donnet Street. You have the floor, Madam.
Thank you. Mr. President, members of the court, it is my privilege to address the court on the nature of the territory that lies at the very heart of this case, the Essequibo. Before the court turns to the legal questions surrounding the 1899 Arbitral Award and its validity, Guyana considers it appropriate to set out concretely what is at stake in these proceedings. As the court will see, Venezuela's claim is not directed at some remote frontier land. It is directed at the heart of my country, the vast majority of its sovereign territory, over 70% of it. Let me begin with the sheer scale of what is being claimed. Guyana is the third smallest country by geographic area in South America, comprising no more than 215,000 square kilometers of land. Venezuela, by contrast, is more than 4 times larger. The area claimed by Venezuela comprises all of Guyana's land territory lying to the west of the Essequibo River, after which the region is named. It accounts for almost 3/4 of Guyana's total land territory, a vast expanse of about 159,500 square kilometers. 6 of Guyana's 10 administrative regions are located within it. I respectfully ask the court to pause on this figure. Venezuela is claiming almost 3/4 of Guyana's sovereign territory, the land in which much of Guyana's population lives, where much of its economic activity takes place, and where its most precious natural, ecological, and cultural treasures are found. For a small developing nation, the loss of nearly 3/4 of its territory would not be a border adjustment. It would be the dismemberment, indeed, the effective destruction of the country. I turn now from the size to the character of the territory Venezuela claims, because its significance to Guyana is not only a matter of size, it is a matter of what the land contains and what it means to our Guyanese people. Guyana's name is aptly derived from an Amerindian word, Guyana, meaning the land of many waters. That is because Guyana possesses a vast hydrographic network consisting of 14 major drainage basins. The Essequibo River is by far the longest, extending some 1,014 kilometers, making it one of the largest rivers in South America. Its major tributaries, the Potaro, the Cuyuni, the Mazaruni, and the Rupununi, all flow through the Essequibo region. These rivers are the arteries of our national life. For the people who live in the Essequibo, they are how communities stay connected and communicate and trade with one another. They are the source of fresh water and the lifeblood of ecosystems that support biodiversity and vital carbon sinks for current and future generations. The natural endowment of the Essequibo region includes more than its rivers. The region is also lined by interconnected mountain ranges, including the Pacaraima Mountains. This is where Guyana's highest mountain, Mount Roraima, forms a tripartite boundary among Guyana, Venezuela, and Brazil. In the very center of the Essequibo region lies the Irocrama rainforest, the green heart of Guyana, one of the last 4 untouched tropical rainforests in the world and a site of global ecological significance. This pristine and delicate environment encompasses a vast area that is universally recognized as rich in diverse species of plants, animals, and insects, including many threatened with extinction. It is a sanctuary for conservation, scientific research, and ecotourism. Guyana has designated 371,000 hectares of pristine forest at Irocrama to promote the conservation and the sustainable and equitable use of tropical rainforests. The ecological significance of the Essequibo region is matched by its economic importance. The region is the engine of our economic development. Gold mining in parts of the region dates back to the 19th century. Considerable deposits of bauxite and manganese are also found in the Essequibo region. There is significant potential for the exploitation of oil and natural gas in the waters adjacent to its coast. These natural endowments are essential to Guyana's economic development. The region also supports substantial agricultural activity, from rice cultivation along the low-lying coastal areas to cattle ranching in the upper Essequibo area, which supplies beef for export. I have described our land. Let me now speak of the people, because the Essequibo is not merely territory. It includes the people who inhabit it, who administer it, and who belong to it, including my own family. According to the most recent census conducted in 2022, the Essequibo region has a population of 313,175, more than 1/3 of Guyana's entire population. These include members of 9 indigenous groups, the first inhabitants of this land. The remainder of the population reflects Guyana's rich ethnic and racial diversity, including descendants of Dutch settlers, the first Europeans to occupy the territory, and descendants of Africans and Asians brought to this land as slaves and indentured servants respectively by Dutch and later British colonizers between the 17th and 19th centuries. As Guyana's agent, Mr. Greenwich, will shortly explain, it is a historical fact that there was no Spanish colonization or permanent settlement anywhere in this territory. The Spanish may have been the first Europeans to set their eyes on the vast northern coast of South America or to claim it, but they never established a presence of any significance there, nor have they ever administered it. As Mr. Greenwich will explain, the British followed the Dutch into the Essequibo region during the first half of the 19th century, forged alliances with the various indigenous communities, explored and mapped the area, and expanded British settlement and administration beyond the coast into the interior. There was never any Spanish or Venezuelan administration there. British administration deepened in the second half of the 19th century and continued until Guyana's independence in May 1966. Since then, Guyana has exercised full sovereignty and governance over the Essequibo region. It administers education through schools across the region. It operates postal services, manages fisheries, enforces environmental regulations, and invests in infrastructure projects. It collects taxes through the Guyana Revenue Authority. Guyana also conducts national and regional elections in the Essequibo region, as it does everywhere in Guyana. In the last elections held on September 1, 2025, 9 members of parliament were elected from geographical constituencies in the Essequibo. These are not abstractions. In exercising their democratic right to vote and choosing their representatives, the people of the Essequibo affirm their commitment to and identification with the sovereign state of Guyana. Mr. President, members of the court, I have sought to show in concrete human and physical terms what the Essequibo region is. It is an integral and essential part of Guyana. Its geography, its economic activity, its culture, and the continuous governance of its land and peoples, first by the Dutch, and then by the British, and since 1966 by Guyana itself, are not matters of abstract historical interests. They are the substance of Guyana's national life. They are an indelible feature of Guyana's national and cultural identity, and they are the crucial foundation for Guyana's security and development. Guyana has no designs on anyone else's territory, but we insist on our rights to our own territory, which, by virtue of the Arbitral Award of 3rd October 1899, includes Essequibo. Guyana's legal team will explain why that award remains legally valid and binding on both Venezuela and Guyana, and why Venezuela's challenges to it should be rejected. I am very grateful for the court's attention, and I ask that you invite Mr. Carl Greenwich to the podium to make Guyana's next presentation. Thank you.
I thank Ambassador Street. I now invite the agent of Guyana, Honorable Carl Greenwich, to address the court. Sir, you have the floor.
Mr. President, members of the court, it is my great privilege to address you this morning, and I will continue Guyana's presentation on the territory in dispute. Ms. Street discussed the land and its people. I will now briefly describe its history as part of a Dutch and then a British colony in the period leading up to the boundary dispute with Venezuela that began in the middle of the 19th century. Mr. Reichler will then carry the story forward through efforts by Great Britain and Venezuela to resolve this dispute with the support of the United States, culminating in 1897 with the execution and ratification of the Treaty of Washington, which enshrined the agreement to submit the dispute to arbitration. The post-Columbian history of our territory begins with the arrival of the Dutch in 1598. They were the first Europeans to establish themselves in what is now Guyana. By 1616, they had founded the colony of Essequibo, erected Fort Kaikoverall along the Mazaruni River, west of the Essequibo, as their seat of government, and begun to settle and administer the territory stretching westward toward the Orinoco. 5 years later, in 1621, the States General granted the Dutch West India Company its charter, by which it took charge of running the colony. In 1744, the seat of Dutch administration was moved to Fort Zeelandia. And the Spanish? They were nowhere to be found, not east of the Orinoco at any rate. Their nearest outpost was San Tome on the banks of the Orinoco. This was the easternmost Spanish settlement. The Spanish governor there was candid about his predicament. The settlement, he wrote, was so far distant from other Spanish possessions, the nearest being Venezuela, more than 650 kilometers away. Later, a settlement at Upata, slightly south of San Tome, was established. Spain never settled any territory farther east of the Orinoco. Spanish attempts to do so were repelled by the Dutch. The reality was enshrined by the Treaty of Munster in 1648. Spain recognized Dutch independence and expressly accepted the territorial status quo on the South American mainland. In 1730, the Treaty of Utrecht reinforced that of 1648, confirming Dutch authority over the territory and settlements it had established in its South American colonies, which then included territory west of the Essequibo River. Over the course of the 18th century, the Dutch moved deeper into the interior of the Essequibo region and further westward along the Atlantic coast. This map, produced in 1748, shows the extent of Dutch settlement and administration of the Essequibo River at that time. The Dutch were then settled along the Pomeroon River, which still bears its original name, as well as Cape Nassau, Moruga, Sprout, Weimar, and Amakura at the mouth of the Orinoco River. The extensive Dutch settlement of this territory during the 17th and 18th centuries is evidenced by the Dutch names maintained to the present day of the villages, towns, rivers, and other geographic features. 35 of these place names are now listed on your screens at tab 4 of your folders, along with their geographical coordinates. In sharp contrast to the widespread Dutch settlement of the territory, lying between the Essequibo and Orinoco rivers, there were no Spanish settlements east of the Orinoco. Venezuela recognizes Dutch presence on the west bank of the Essequibo, but seeks to characterize this as very limited and temporary in nature. That is historically inaccurate and not supported by the evidence. What Venezuela does not say, and what it cannot say, is that there was any Spanish settlement or administration in this territory. By the early 19th century, the Dutch were displaced, but neither by Spain nor by Venezuela. They were displaced by Great Britain. After tensions arose between the two powers, in part because of the Dutch had backed the American colonies in their struggle for independence, Britain seized the Dutch possessions in this area, and in the early 1800s. In 1803, the Netherlands ceded its colonies to Britain under the Articles of Capitulation of Demerara and Essequibo. At the close of the Napoleonic Wars, the Dutch formalized the transfer. The 1814 Convention of London ceded the colonies of Essequibo, Demerara, and Berbice to Britain. The Treaty of Paris of 1850 confirmed it. Only in Suriname in the east was returned to the Dutch. For the first decade and a half after the Treaty of Paris, Britain maintained the separation of Berbice and the Essequibo Demerara. In 1831, King William IV merged them into one to form the colony of Great Britain. The colony of British Guyana. With a newly consolidated colony, Britain set about increasing its understanding of what it possessed. It began by commissioning a survey of the territory, which included an effort to determine its western boundary, that is, where British Guyana ended and the nascent Republic of Venezuela began. Robert Schomburgk was entrusted with this task. Schomburgk, a German-born botanist, surveyor, and geographer of considerable distinction. Between 1835 and 1839, Schomburgk carried out 3 major expeditions into the territory west of the Essequibo under the auspices of the Royal Geographical Society. In the process, he traversed vast swathes of the interior. Venezuela's rejoinder dismisses Schomburgk as a mere Russian-Prussian technician who drew boundary lines, different from the one that had been known until then. In fact, until then, there was no known boundary, much less one that was recognized or agreed. The Schomburgk expedition was an effort to establish such a boundary. In 1840, following his earlier excursions through the territory west of the Essequibo River, Great Britain directly commissioned Schomburgk to map out the colony's borders. The intention had been to share the results with Brazil and Venezuela and to inform Venezuela in advance of Schomburgk's mission and its objectives. The Venezuelan president, José Antonio Páez, did not protest. In fact, he welcomed Schomburgk's mission. British colonial records report that President Páez conceived this to be the best opportunity to settle definitively this affair, which interests both nations. He also proposed that the two countries set up a joint commission to conduct the survey, prefatory to concluding a treaty of limits. But by the time the Venezuelan president's message reached London, Schomburgk had already set out on his mission. Between 1841 and 1844, Schomburgk conducted 5 expeditions into the interior, shown on this map. In the first trip, shown on the map as Trip 1, he journeyed along the Berima and Cuyuni rivers and raised British flags and markers at Berima Point on the coast. In his own words, the British Empire acquired, therefore, Guyana, with the same claims to the termini of its boundaries as held by the Dutch before it was ceded by treaty to Great Britain. Of equal importance is the determination of the western boundary of British Guyana, the limits of which have never been completely settled. In this report, Schomburgk documented the chain of Dutch settlements stretching westward to the Berima River and noted that disinterested scholars in the 18th century had uniformly treated the Berima River as the western edge of Dutch territory. He placed the British frontier at the Amakura River, 4 miles west of Berima Point, as is no doubt the most natural limit west of the possessions of the Dutch. The map and boundary line he produced became what is known as the Schomburg Line. It became the basis of British territorial claims in the late 19th century, including that of the arbitration against Venezuela, that resulted in the award of the 3rd of October 1899. The Schomburg Line that the British presented to the Arbitral Tribunal is shown here highlighted in yellow. The actual British claim line in the arbitration is highlighted in green. Venezuela's reaction. The Schomburg Line triggered consternation in Venezuela, which protested it and asserted its own claim to the territory east of the Orinoco River, extending to the Essequibo River, as shown here, highlighted in red. In asserting this claim, Venezuela did not point to any military bases or to settlements it had built, officials it had posted, or taxes it had collected. It pointed to the heavens, quite literally. Venezuela invoked the papal bull of 1493, issued by Pope Alexander VI, a Spaniard, and declared on that basis that the right of Spain to the territory of America has always been indisputable in the eyes of all nations of the world. The treaties by which Britain inherited the Dutch colonies were, in Venezuela's view, void because the Netherlands had conveyed to England what did not belong to her and what she knew did not belong to her. End of quote. Great Britain rejected Venezuela's claim and continued to promote settlement of the region under its administration within the area encompassed by the Schomburg Line. The British made efforts to reach an understanding with Venezuela on the location of the boundary. Various proposals were exchanged, beginning in the 1840s, but no agreement was reached. In the meantime, British settlement continued to expand westward within the Schomburg Line. Venezuela felt powerless to stop it and grew increasingly desperate in attempting to prevent further British consolidation. Some progress towards a resolution was made in 1850 when Britain and Venezuela exchanged letters in which each undertook not to encroach further on any disputed territory until a final settlement on the boundary was reached. There was a problem with the so-called 1850 agreement, however. It did not define or describe the territory that was disputed, leaving this for each party to determine for itself. Over the course of the following decades, Venezuela repeatedly complained about what it considered Britain's frequent violations of the 1850 agreement, including its extension of control over the disputed territory between the Essequibo and Orinoco rivers. In 1877, Venezuela's minister in London, José Rojas, approached the British Foreign Office with a proposal for an amicable settlement. By 1880, formal negotiations had begun, but no progress was made. In November of 1883, with the prospect of a diplomatic settlement bleak, Venezuela proposed for the first time that a territorial dispute be settled by arbitration, pursuant to which the decision of an arbitrator, who freely and unanimously chosen by the two governments, would judge and pronounce a sentence of a definite character. Great Britain rejected Venezuela's proposal for arbitration. Undoubtedly, it offered to arbitrate only the territory west of the Schomburg Line, that is on Venezuela's side of the line. This was quite understandably not acceptable to Venezuela. Faced with British intransigence on the scope of the arbitration, on the 20th of February 1887, Venezuela broke off diplomatic relations with Great Britain. In its exasperation with the British, Venezuela turned to the United States for support and assistance, asking the US to use its power and influence to persuade the British to submit to arbitration, title to the entire territory claimed by both Britain and Venezuela, that is, all the land lying between Essequibo and the Orinoco rivers. The history is clear. and established by the evidence before the court. It was Venezuela that insisted on arbitration. It was Venezuela that brought the United States into the picture to help it obtain the arbitration agreement with Great Britain that it was unable to obtain on its own. And ultimately, as Mr. Reichel will show you, with the support of the United States, Venezuela secured the arbitration agreement on which it had been insisting for more than a decade in the form of the 1897 Treaty of Washington. Right up to the President, Venezuela heralded and celebrated the treaty as the accomplishment of its long-sought objective and profusely expressed gratitude to the United States for its indispensable contribution to that end. Venezuela maintained this attitude towards the treaty and its implementation for the next 60 years. It neither questioned, challenged, nor criticized the treaty. In contrast, in these proceedings, Venezuela takes exactly the opposite position. It attacks the very treaty, claiming now that it was unlawful and invalid on several grounds. At this point, I pass the baton to Mr. Reichler and invite you to call him to the bar to show that there is no merit to any of Venezuela's belated and totally unpersuasive challenges to the treaty. Mr. President, members of the court, I thank you for your kind attention, and I ask that you invite Mr. Reichler to the podium, perhaps after a short break.
I thank the agent for his presentation. Before I give the floor to the next speaker, the court will observe a break. The hearing is a break of 10 minutes. The hearing is suspended.
Please be seated. The sitting is resumed. I now call Mr. Paul Reichler to the podium. You have the floor.
Thank you. Mr. President, members of the court, it is, as always, an honor for me to appear before you. And it is a privilege, as well as a great responsibility, for me to represent the Cooperative Republic of Guyana in a case that the Honorable Foreign Minister has described as existential for his state. I will address you on the 1897 Treaty of Washington, the treaty between Venezuela and Great Britain by which they agreed to arbitrate their territorial dispute, and pursuant to which the dispute was arbitrated 2 years later, resulting in the award of 3 October 1899. In these proceedings, of course, Venezuela challenges the validity of that award. The first reason it gives for the alleged invalidity of the award is the purported invalidity of the 1897 treaty. Venezuela contends that the treaty was invalid, and therefore that the arbitration that was conducted pursuant to it was also invalid. And for this reason, the legality of the 1897 treaty has been put into issue in this case. As the court is well aware, Venezuela accepted, respected, and complied with the 1899 Arbitral Award for more than 60 years. The very first time it formally challenged the validity of the award was in a letter from its permanent representative to the UN to the Secretary General in February 1962. At that time, and in subsequent presentations to the United Nations, Venezuela made clear that although it had changed its position on the award of 1899, it continued to regard the 1897 treaty as a valid treaty. It was not until 1963, 66 years after it ratified the treaty, that Venezuela first began to find fault with it. My presentation on the treaty will be in 4 parts. In the first part, I will set out the issues in this case on which both Venezuela and Guyana agree, or at least which they do not dispute. In parts 2 to 4, I will address the 3 specific challenges Venezuela has made to the treaty's validity, all of which Guyana considers groundless. I turn to part 1. As a general matter, the parties do not dispute the circumstances that led up to the 1897 treaty. In particular, they agree that the dispute over the boundary between Venezuela and British Guyana began to heat up in the 1840s, and that between then and the early 1980s, Venezuela and Great Britain exchanged various proposals for delimitation of the boundary, all without success. Both states claimed the entire territory between the Essequibo River in the east and the Orinoco River in the west. Their respective proposals and counterproposals failed to resolve or even substantially narrow this dispute. Throughout this 40-year period, Venezuela complained about what it considered the westward expansion of British settlement in the territory between the 2 rivers. Although, as you have heard, an agreement was reached in 1850 not to expand further into what they both referred to as disputed territory, Venezuela complained that British expansion continued. Recognizing that it was unable to stop the British diplomatically or militarily, Venezuela implored them to settle the dispute by arbitration. But the British refused. As Venezuela acknowledged in its counter-memorial, quote, it had repeatedly proposed to Great Britain to settle the territorial dispute by arbitration, but Great Britain had systematically refused such solution, end of quote. It is also undisputed that between 1883 and 1895, in the face of what it claimed to be ongoing British settlement in the disputed territory, Venezuela turned to the United States for support, specifically requesting U.S. intervention with the British to obtain their agreement to settle the dispute by arbitration. To this end, this is what Venezuela's foreign minister wrote to the U.S. Secretary of State in 1883. To carry this controversy to a practical ground and possible termination, there is, in the opinion of the President of Venezuela, only one, and at the same time very simple way, arbitration. And for arbitration, there is only one government who could propose it with real effect and decide the question of boundaries to the satisfaction of Venezuela, the United States of America. It is also agreed that the United States responded sympathetically to Venezuela's entreaties, that it remonstrated with the British over the alleged westward expansion of British Guyana, and that it insisted on arbitration of the territorial dispute. No less a figure than the President of the United States, Grover Cleveland, championed Venezuela's cause. In September 1988, Venezuela's mission in Washington wrote this: "To the President of the United States, Grover Cleveland, my country is largely indebted for his sympathy and the notion taken by him toward the government of Great Britain in showing that government that the United States was not indifferent to the unwarranted acts of encroachment by Great Britain on the territory of the Republic of Venezuela. The timely interference on the part of President Cleveland has, for the present, stopped the English government in her attempted acts of spoliation, encroachment, and appropriation to herself of very nearly one-third of our whole republic. My government and people feel that in President Cleveland they have a friend and protector." Despite the efforts of President Cleveland and his administration, the British remained opposed to arbitration with Venezuela, leading Venezuela to break diplomatic relations. In December 1894, with the territorial dispute continuing to fester, Venezuela's minister in Washington, Jose Andrade, a name you will hear frequently in this presentation, wrote to the U.S. Secretary of State, citing the threat of further British expansion and urging the United States once again to intervene on Venezuela's behalf. As Your Excellency will understand, the dispute already has a phase that we would call threatening, given that the colonial authorities are preparing to expand their jurisdiction even further, and to thus enter into regions where the Republic has established regular centers. In view of this, my government reiterates to the United States government its request for effective and direct intervention, which our Minister Plenipotentiary presented to the Department of State in Washington some time ago and has continually ratified. Within days, President Cleveland responded in an address to the U.S. Congress. I shall renew the efforts heretofore made to bring about a restoration of diplomatic relations between the disputants and to induce a reference to arbitration, a resort to which Great Britain so conspicuously favors in principle and respects in practice, and which is earnestly sought by her weaker adversary. When the British continued to resist President Cleveland's demand for arbitration, the U.S. applied greater pressure. In July 1895, the new U.S. Secretary of State, Richard Olney, another name that features prominently in the narrative, instructed the U.S. mission in London to convey the following admonition to the British authorities. The duty of the President appears to him unmistakable and imperative. Great Britain's assertion of title to the disputed territory, combined with her refusal to have that title investigated, being a substantial appropriation of the territory to her own use, not to protest and give warning that the transaction will be regarded as injurious to the people of the United States,
as well as oppressive in itself, would be to ignore an established policy with which the honor and welfare of this country are closely identified. When the British ignored this warning, President Cleveland took matters into his own hands. In his December 1895 address to the U.S. Congress, he expressly invoked the Monroe Doctrine against the expansion of British Guyana, warning the British that, quote, its enforcement is important to our peace and safety as a nation and is essential to the integrity of our free institutions and the tranquil maintenance of our distinctive form of government. Sentiments in the United States, including at its highest levels of government, ran so strongly in favor of Venezuela and against Great Britain that, as Venezuela's foreign minister told the UN General Assembly in 1962, quote, the United States was on the verge of going to war with Great Britain. In this extremely grave situation, that's how Venezuela described it, President Cleveland, with the full support of the U.S. Congress, went beyond words to concrete action. He announced the creation of a new presidential commission of experts, headed by a U.S. Supreme Court Justice, David Brewer, to investigate and report on the true boundary between Venezuela and British Guyana, which the U.S. would then seek to enforce. As President Cleveland explained, when such report is made and accepted, it will, in my opinion, be the duty of the United States to resist by every means in its power, as willful aggression upon its rights and interests, the appropriation by Great Britain of any lands or the exercise of governmental jurisdiction over any territory, after which investigation we have determined of right belongs to Venezuela. This measure, with its implicit suggestion of military intervention by the U.S., finally broke Britain's resistance to arbitration of the dispute. In its written pleadings, Venezuela acknowledges this. If the British finally accepted to enter into an arbitration process, it was under U.S. pressure, and to ward off the risk of seeing the work of the Venezuela Boundary Commission concluding, as it had to, that the true boundary had always been the one claimed by Venezuela. As Venezuela further acknowledged in its counter-memorial, it is a fact that Venezuela requested the protection of the United States in order to resist Great Britain's conduct and reach a peaceful solution to the territorial dispute. It was clear that the possibility of submitting the dispute to arbitration could have materialized only with the support of the United States. And Venezuela continued. Great Britain accepted arbitration only because of the pressure put on it by the United States. Neither this conclusion nor the antecedent events that led up to it can legitimately be disputed by Venezuela at this stage of the proceedings, nor can the fundamental features of the ensuing negotiations that led to the 1897 treaty. In particular, it is beyond dispute that the negotiations were conducted until the final stage directly between U.S. Secretary of State Richard Olney and the British ambassador in Washington, Lord Julian Pauncefote. It is uncontested that Venezuela appointed a team of 2 representatives, Jose Andrade, its minister in Washington, and James Storrow, an American attorney who had represented Venezuela before President Cleveland's Boundary Commission, to liaise and engage directly with Secretary Olney and assure that Venezuela's interests were reflected in the treaty negotiations. It is also undisputed that the negotiation of the treaty took place between January and November 1896, that a draft agreement was presented to the Venezuelan government in November 1896, that further negotiations took place directly between Venezuela and Great Britain thereafter, and that Venezuela then authorized Mr. Andrade as Minister Plenipotentiary to sign it, which he did in Washington on 2 February 1897. Later that month, on 20 February, the President of Venezuela, General Joaquin Crespo, submitted the treaty to the Venezuelan Congress with a message calling for its ratification. In so doing, the Venezuelan president expressed gratitude to the United States for the part it played in negotiating the treaty. It is eminently just to acknowledge that the great republic endeavored persistently to direct the matter by the most favorable route, and that the outcome achieved represents an effort of intelligence and will worthy of praise and gratitude from those of us who are familiar with the intricate details of this very complicated matter. The treaty was then ratified by the Venezuelan Congress by legislative decree on 17 April 1897. The final page of this decree is at tab 5.1 of your folders. None of these facts, none of them, are or can legitimately be disputed. I turn to part 2 and Venezuela's main challenge to the validity of the 1897 treaty. This is its contention that it was excluded from the treaty negotiations and that the treaty was, in its words, negotiated by the U.S. and Great Britain, quote, behind Venezuela's back, in collusion with one another to further Britain's interests at Venezuela's expense, with the result that, to cite Venezuela's written pleadings, the treaty was, quote, prejudicial to the interests and dignity of Venezuela in respect of crucial issues. Venezuela argues in particular that as a result of this purported British and American conspiracy, its views on 2 issues that it considered most critical, concerning the acquisition of title by prescription and respect for the 1850 agreement between Venezuela and Great Britain, were not taken into account or reflected in the treaty. The argument is that this purported Anglo-American cabal not only prejudiced its interests, but constituted a fraud on Venezuela within the meaning of Article 49 of the Vienna Convention on the Law of Treaties, sufficient to invalidate the treaty. On the same allegations, Venezuela argues that it ratified the 1897 treaty in error, as defined by Article 48 of the Vienna Convention, on the mistaken understanding that the treaty text negotiated on its behalf by the United States had protected its vital interests, only to find out during the arbitration 2 years later that it did not. Mr. President, neither Venezuela's contention of fraud nor its contention of error withstands scrutiny or is even plausible. In the first place, its contentions are counterintuitive. They strain credulity, requiring you to conclude that the United States, which between 1883 and 1896 had consistently supported Venezuela in opposing British colonial expansion and demanding that Britain accede to arbitration of the territorial dispute, made a complete volte-face when negotiation of the arbitration agreement began, by switching sides and supporting Britain's interests in the disputed territory to the prejudice of Venezuela's. For Venezuela, this would be a hard sell in any case, let alone a case in which it expressly agrees, as you have seen, that but for the full support of the United States and the pressure it applied to Great Britain, including the threat of U.S. military intervention, the British would never have agreed to arbitration and would have continued to strengthen their hold on the disputed territory in the face of Venezuela's incapacity to stop them. But beyond its illogic, Venezuela's argument is also counterfactual, completely so. It is thoroughly contradicted by the contemporaneous documentary evidence of the treaty negotiation process that is part of the record in this case. I will take you to the key documents presently. The arbitration agreement was largely negotiated directly by the British ambassador to the United States, Lord Pauncefote, and the U.S. Secretary of State, Richard Olney, on behalf of Venezuela. At the time, there was no objection by Venezuela. There is no evidence of any kind of such an objection. To the contrary, the evidence shows that Venezuela trusted Mr. Olney, as well as his boss, President Cleveland, to protect its interests. And it believed Secretary Olney would have more influence with the British than its own representatives. This is confirmed by what Venezuela's Ministry of Foreign Affairs reported contemporaneously in August 1896 upon reviewing the correspondence between the U.S. and Great Britain in the negotiation process. The correspondence once again highlights the positive role of the Great Republic of the North in an issue of paramount interest to the entire hemisphere, due to its close connection with the integrity of the territories constituted as free and sovereign nations. Furthermore, having been considered by the President of the Republic and the Council of Ministers, the nature of this publication, expertly and wisely defended by the Department of State in Washington, and setting out the principles and doctrines to which Venezuela adheres in order to uphold its rights and dignity in one of the gravest issues recorded in its political annals, has led to the decision to produce a special edition in Spanish of all the notes comprising the above-mentioned correspondence, as both a pledge of recognition to the government of the United States and a welcome contribution to the promotion of principles so gallantly supported by the great people of the North in support of common security and international peace. This contemporaneous Venezuelan assessment of the role played by the U.S. demonstrates that Venezuela was manifestly content with the way Secretary of State Olney handled the treaty negotiations to that point. Venezuela thus focuses on a later stage of the negotiations between September and November 1896, during which the subjects about which it expresses most concern, the acquisition of title by prescription and preservation of the 1850 agreement, were directly addressed by Secretary of State Olney and Lord Pauncefote. Venezuela's principal contention now, as opposed to what it said contemporaneously, is that during this stage of the negotiations, the two representatives of Venezuela, Messrs. Andrade and Storo, were kept in the dark by Secretary of State Olney and denied the opportunity to defend or even explain Venezuela's interests. This is entirely fallacious. It is completely refuted by the documentary evidence, as you will now see. Far from keeping Venezuela's representatives at arm's length, on 12 September 1896, Secretary of State Olney sent Mr. Storo an early draft of the clause on prescription, indicating he would come to meet Mr. Storo at Mr. Storo's home in the evening, prior to a meeting with Lord Pauncefote the following day. On your screens is a copy of Mr. Olney's message to Mr. Storo and the enclosed treaty text on prescription. You will note the highlighted portion of the text showing a proposed prescription period of 40 years. explaining that any of the disputed territory which had been under the actual, exclusive, and continuous dominion and control of one of the parties for that period would be held to form part of the territory of that party. Mr. Storrow wrote back to Mr. Olney on 17 September 1896. Referring to their recent meeting at his home, he said, "Our views agreed the other day, so that I thought it enough to answer your telegram, no change." Mr. Storrow continued, however, by advocating for a longer period of prescription than the 40-year period initially presented by Mr. Olney. Settlements by British subjects living under British rule in territory administered solely by British rule, if long continued, will certainly, I think, give title. 60 years is the classic period. I would agree to less as a rule rather than lose an arbitration. Further down the page, Mr. Storrow also highlighted the importance to Venezuela of the 1850 agreement. I do not think that the truce of 1850 could be waived or impaired, or that it ought to be. The evidence shows that far from ignoring them, Mr. Olney received Mr. Storrow's proposals, acted upon them, and incorporated them into his own proposal to Lord Pauncefote, and he succeeded in achieving them. This is apparent from the next set of documents from October 1896, which comprise the written communications between Mr. Storrow and Mr. Olney, and between Mr. Olney and Lord Pauncefote. On these issues, prescription and the 1850 agreement, they show unmistakably that Venezuela's views were fully taken into account and advanced by Mr. Olney in his negotiations with Lord Pauncefote, and Venezuela's objectives were achieved. On the 26th of October, for example, Mr. Storrow sent Mr. Olney a revised draft of the prescription clause, accompanied by a handwritten note. It states, in reference to the number of years required for prescription to take effect, filling in the blanks with 60, I see no objection to the actual occupation part. Mr. Storrow's note continues, I will try to write a couple of sentences more and send these to your house in the afternoon. And Mr. Storrow did just that. Here is the text he sent to Mr. Olney that afternoon. The arbitrators shall adjudge a title by prescription or adverse occupation to be a good title, and shall consider 60 years as a sufficient period to establish a title by prescription. But the arbitrators may and shall, the next word is illegible, and apply all the rules of law and fact appropriate to this case, as far as they do not contravene the foregoing provision. The British position was that the prescription period should be no more than 30 years, which would have facilitated their claim of title to any of the disputed territory that they had consistently occupied since as late as 1867, 30 years before the treaty then under negotiation would enter into effect. The British proposal can be found in Venezuela's counter-memorial at Annex 169. Mr. Storrow sent another note to Mr. Olney on 28 October 1896. And again, it shows the intimacy of the relationship between Venezuela's representatives and the U.S. Secretary of State. Mr. Andrade and I will come to your house at 8:15 tonight unless we hear to the contrary. The date of this meeting was propitious because the following day, 29 October, after consulting with Venezuela's two representatives the previous evening, Mr. Olney sent to Lord Pauncefote a new draft of the treaty. In respect of prescription, Mr. Olney wrote, I cannot recede from my original suggestion as to a conventional term of prescription further than to consent to 50 years being substituted for 60. Mr. Olney explained to Lord Pauncefote that he could not agree to a shorter term than 50 years because anything less might undermine the force of the 1850 agreement. by which the parties had pledged to forego further expansion into the disputed territory. A 50-year prescription rate would preserve the 1850 agreement because it would disregard any occupation of the disputed territory that commenced after 1847, assuming again that the treaty would enter into force in 1897. By contrast, the 30-year prescription period proposed by the British, or even a 40-year period, would have conferred title on any continuous occupation commenced by 1857. And that, of course, would contravene the 1850 agreement, which is why Mr. Olney would not agree to that. As Mr. Olney explained, if a shorter term be stipulated, it is certain to be urged, and with great force, that the agreement of 1850 is thereby waived, at least pro tanto. The documentary evidence thus shows Mr. Olney's firm advocacy of Venezuela's positions on both the prescription period and on the 1850 agreement. Now, earlier in that letter, Mr. Olney explained to Lord Pauncefort that with a 50-year prescription period, there would be no need for the arbitration agreement to include an express reference to the 1850 agreement, because the 50-year prescription period would accomplish the same result, precluding recognition of any occupation of the disputed territory that commenced after 1850. In fact, the 1850 agreement had a major gap, a major lacuna, as our agent told you earlier this morning, consisting of an exchange of letters between Great Britain and Venezuela in which they each abjured any further expansion into disputed territory. They conspicuously failed to identify what or where the disputed territory was, leaving this critical term open to interpretation. Hence, Mr. Olney wrote to Lord Pauncefort, an attempt to construe it will involve us in protracted debate and indefinitely postpone the attainment of the object we now have in view. The agreement, that's the 1850 agreement, will come and should come before the arbitral tribunal in the natural course and will be interpreted by that tribunal by the aid of facts, documents, and considerations of which we cannot now know anything. On 30 October, Lord Pauncefort reported to his Prime Minister, Lord Salisbury, on his exchanges with Mr. Olney on these subjects. Quote, I have tried in vain every argument and put the greatest pressure on him to obtain a further reduction, that is, in the prescription period. He, that is Olney, says he cannot consent in justice to Venezuela. He contends that a limit of 30 or even 40 years would nullify the agreement of 1850, to which the arbitrators must be left to give such effect as they think right, and that 50 years is the lowest period of prescription suggested by jurists and does not preclude or affect claims to the territory based on any other title. It bears emphasis that what this evidence shows is that far from turning his back on Venezuela's representatives or concluding with the British to protect their interests rather than Venezuela's, the U.S. Secretary of State did exactly the opposite of what Venezuela has pleaded in this case. As these contemporaneous documents demonstrate, Mr. Olney took Venezuela's representatives directly into his confidence, shared drafts of the treaty text with them, received their proposals on the key issues with which Venezuela was concerned, incorporated them into his exchanges with Lord Pauncefort, refused to concede any ground, in spite of what Lord Pauncefort called every argument and the greatest pressure, and ultimately he delivered what Venezuela's representatives had requested: a prolonged period of prescription of 50 years and preservation of the 1850 agreement. The terms of the draft treaty were in fact agreed with the approval of Venezuela's two representatives. This is what Mr. Olney reported to Justice Brewer, then the chairman of President Cleveland's Venezuela Boundary Commission, on 10 November 1896, shortly after the conclusion of his exchanges with Lord Ponsford. The United States and Great Britain are in entire accord as to the provisions of a proposed treaty between Great Britain and Venezuela. The treaty is so eminently just and fair as respects both parties, so thoroughly protects the rights and claims of Venezuela, that I cannot conceive of it not being approved by the Venezuelan President and Congress. It is thoroughly approved by the Council of Venezuela here and by the Venezuelan minister at this capital, referring to Mr. Storrow and Minister Andrade. Mr. President, the evidence you have now seen from the contemporaneous documentary record thoroughly defeats Venezuela's challenge to the 1897 treaty, that it was somehow negotiated behind Venezuela's back without involvement of its representatives and failed to take account of its interests. There is absolutely nothing in this record to contradict Mr. Olney's statement that the treaty he negotiated with Lord Ponsford was, quote, thoroughly approved by the Council of Venezuela and by the Venezuelan minister in this capital. Mr. Olney's sense that the treaty would be approved by the President and Congress of Venezuela also proved to be spot on, as you will now see. At the very time of Mr. Olney's letter to Justice Brewer, Mr. Storrow and Mr. Andrade were en route to Caracas to obtain the Venezuela government's approval of the draft treaty. On 29 November, Mr. Storrow sent Mr. Olney a detailed report of their meetings with the President, the Foreign Minister, other government officials, and a commission of experts the government had established to analyze the treaty. Because of the report's length, 9 pages, I will show you now only the most important parts, but I think you will find it helpful to read it in its entirety, and for that reason we have included it at tab 5.2 of your folders. At page 2, the report describes the reactions of the Venezuelan president and other senior officials with whom Mr. Storrow and Mr. Andrade had met. This is Mr. Storrow writing. Mr. Andrade afterwards had a long talk with him, the president, and afterward with the Minister of Foreign Affairs and Dr. Brunal Arra, Minister of the Treasury, the strongest man in the cabinet. They were all satisfied with the treaty and said there should not be a moment's hesitation about adopting it. I have myself seen Dr. Brunal and Dr. Rojas, that's the Minister of Foreign Affairs, the latter quite frequently, and they are entirely clear on the subject. Page 4, the report describes the meeting Mr. Storrow and Mr. Andrade had with the commission of experts appointed to analyze the treaty and their discussion on the subject of prescription. One of the experts, Dr. Sejas, opposed on constitutional grounds any recognition by Venezuela of prescription as a source of title to territory. He was the only commission member to take this view. However, quote, Dr. Sejas finally admitted that he had no doubt prescription applied and that the arbitrators would apply it, but that to admit it in terms of the treaty would be to violate the rule of the Constitution against cessions of territory. Mr. Storrow and Mr. Andrade responded. We said it was not a concession. Prescription was, I thought, our strongest ground, and I wanted GB to agree to it, and of all possible terms, 50 years was the best for us. A week later, on 7 December, Mr. Andrade sent a telegram to Mr. Olney in which he reported this. Memorandum accepted. Will be published here Monday afternoon. Extra session of Congress will be called as soon as possible. Am authorized to sign the treaty with small exceptions such as provisions filling vacancies in the case of death or disability. But Venezuela expect by treaty or by diplomatic correspondence through you agreement to prevent aggressive or unfriendly acts near line of contact, and also no new mine concessions shall be granted. 2 days later, Dr. Rojas, the foreign minister, wrote to Mr. Andrade, indicating Venezuela's desire for other changes to the treaty, 2 of which he regarded as particularly important. One involved the appointment of arbitrators, which I will discuss in part 3 of my presentation. The other concerned prescription. Dr. Rojas was content with prescription as a source of title to territory, noting that, quote, Venezuela has declared itself in favor of this system. He was also content with the 50-year prescription period already included in the draft treaty. But he wanted to add to the treaty a clause requiring application of the principles of international law to territorial claims based on prescription. He proposed that the following text be inserted into the treaty. The adverse possession for 50 years referred to in Rule A must be in accordance with the principles of international law, possession in the name of the state and in the capacity of owner, public, continuous, uninterrupted, and peaceful. Dr. Rojas's letter is particularly significant because it directly and fully contradicts Venezuela's argument in the rejoinder that they were opposed to prescription as a source of title, and that Mr. Olney betrayed them and even defrauded them by agreeing with the British on a 50-year prescription rule. That argument is entirely false. At the conclusion of his letter, Dr. Rojas gave this instruction to Mr. Andrade. If, despite the efforts that are urged upon you to make, any of the stated modifications should be rejected in terms that make clear the impossibility of their acceptance, you may dispense with it in the course of the negotiations and even sign the document without the need for new consultation with this office. So determined was Venezuela to get this treaty signed. Mr. Andrade communicated Dr. Rojas's proposal to Mr. Olney in a telegram sent the following day, on 10 December. Later that month, on 28 December, after he returned to Washington, he met with Mr. Olney at his home to discuss the proposals. After the meeting, Mr. Andrade wrote this to Dr. Rojas in Caracas. Mr. Olney found all the conditions commendable, save the one regarding prescription, about which he expressed some discouragement that he deemed it superfluous, believing such an interpretation as that is one that is inconsistent with international law, to be neither possible or likely, and that without need, it would give occasion for Great Britain to delay us with a discussion lasting months or perhaps years from which no benefit would ultimately result. Mr. Andrade, to whom Venezuela granted full powers to sign the treaty, then described how he responded to Mr. Olney. I hinted that if such were his view, I would not insist upon submitting the aforementioned clarification to the British ambassador. And with a nod unmistakable in its meaning, he approved of such disposition. To conclude part 2 of this presentation, it is crystal clear that Venezuela has no legal or evidential basis, none whatsoever, to argue that the 1897 treaty is invalid on grounds that the United States failed to consult with Venezuela during negotiation of the treaty, or that it colluded with Britain behind Venezuela's back, or that it accepted terms that favored British interests to the prejudice of those of Venezuela. The evidence makes clear that the United States did not contravene Venezuela's position on prescription, which was duly reflected in the treaty's final text, or on the continuing validity of the 1850 agreement. In both cases, the United States considered that it had fully protected Venezuela's interest, and the contemporaneous documentary evidence shows that Venezuela agreed that it had done so. I turn to part 3, which I can cover much more quickly. In its written pleadings, Venezuela challenges the validity of the 1897 treaty on the ground that without its consent, the treaty excluded the appointment of any Venezuelan arbitrators. This, too, is a groundless argument, again, completely defeated by the contemporaneous evidence. The draft treaty delivered to Caracas in November 1896 addressed the appointment of arbitrators in Article 2. It provided for a tribunal of 5 members, 2 to be nominated by the judges of the Supreme Court of the United States, 2 to be nominated by the British High Court of Justice, and the 5th to be appointed by the 4 so nominated. This left open the possibility that a Venezuelan could be appointed to the tribunal by the U.S. justices, a possibility of which the British were quite aware and quite uncomfortable. On 8 December 1896, Lord Ponsford wrote to his prime minister that he was a little uneasy whether the U.S. judges may not be urged by Mr. Olney to appoint a Venezuelan as arbitrator because, quote, "we know of no Venezuelan jurist worthy of the name or whom we could consent to entrust with the function of arbitrator in such a case." This statement is certainly offensive to us as well as to Venezuela. We call attention to it only to underscore the adamance of Britain's stance on the clause regarding appointment of arbitrators. Understandably, Venezuela bristled at Lord Ponsford's dismissive view of its desire to appoint one of its nationals to the arbitral tribunal. On 10 December, Venezuela's representative, Mr. Storrow, cabled Mr. Olney from Caracas that, quote, "treaty stands accepted as cabled, but there are sharp attacks about the appointment of arbitrators and cabinet very desirous have one Venezuelan on the tribunal. This would help much with public and Congress." Mr. Olney duly transmitted Mr. Storrow's message to Lord Ponsford the next day. The day after that, on 12 December, Lord Ponsford responded to Mr. Olney, rejecting Venezuela's request. In his words, quote, "it would be a most dangerous departure from the long-established practice of international arbitration. The very reason for taking the nomination of the arbitrators on the side of Venezuela out of the hands of the Venezuelan government and confiding that duty to 2 judges of the Supreme Court was that the latter should appoint arbitrators of U.S. nationality." Faced with this British rejection, Mr. Olney sent a telegram to Mr. Storrow informing him that matter closed between Great Britain and United States. Changes treaty must be made between Great Britain and Venezuela. And that is precisely what happened. On 28 December, Mr. Andrade, having returned to Washington from Caracas, met first with Mr. Olney and then directly with Lord Ponsford. And they reached an agreement on the appointment of arbitrators, an agreement reached by Mr. Andrade with Lord Ponsford, his British counterpart. As recorded in Mr. Andrade's report to Dr. Rojas of 9 January 1897, he, Mr. Andrade, and Lord Ponsford agreed that Article 2 of the treaty would be revised to attribute to Venezuela the appointment of only one of the arbitrators on her side and the other to the United States, it being noted that the Venezuelan appointee would be a judge from the Supreme Court of this country, the United States. Mr. Andrade added that he considered this agreement beneficial to Venezuela. The more I think of it, the more I think that Venezuela, far from wishing to restrict the participation of the United States in the composition of the tribunal, should seek to augment it. The Venezuelan government agreed to the arrangement negotiated by Mr. Andrade and Lord Ponsford, and it decided to exercise its right of appointment by nominating the Chief Justice of the U.S. Supreme Court, Melville Fuller. This meant that Venezuela would be represented on the tribunal by 2 U.S. Supreme Court justices, since it had already been decided that the other representative would be Justice David Brewer, the same Justice David Brewer who was serving as the chairman of President Cleveland's Venezuela Boundary Commission. Mr. Storrow, Venezuela's counsel, considered that this solution gave Venezuela exactly what it wanted. On 26 January, he wrote to Foreign Minister Rojas, quote, "I think you have got what you desired, a clear and formal appointing power of Venezuela on the face of the treaty, precisely the same 2 jurors whom, at Caracas, you told me you preferred." President Crespo also regarded this as a win for Venezuela. In his address of 20 February 1897, he emphasized, quote, "The government deemed it indispensable to introduce into the treaty a modification aimed at ensuring the appointment of the arbitral tribunal with the effective participation of the Venezuelan authorities. This proposal was promptly submitted and the arbitration was accepted." Plainly, there was no fraud or error in regard to the agreement on appointment of the arbitrators. Venezuela was fully informed of the draft treaty text, the subsequent exchanges between Mr. Olney and Lord Ponsford, and the necessity of direct negotiations between Venezuela and Great Britain to resolve the issue. And those negotiations resulted in an agreement with which Venezuela professed its satisfaction. These indisputable facts doom Venezuela's challenge to the validity of the 1897 treaty based on the appointment of arbitrators. I come to part 4, the final part of my presentation concerning, and this concerns Venezuela's claim that it agreed to the 1897 treaty under coercion, as prohibited by Article 52 of the 1969 Vienna Convention. It will take me even less time to dispense with this argument. In the first place, Article 52 of the 1969 Convention has no retroactive application. As the ILC commented, quote, "The Commission considered that there is no question of the article having retroactive effects on the validity of treaties concluded prior to the establishment of the modern law." In 1897, customary international law did not recognize coercion as a basis for invalidating a treaty. For the legal discussion, I refer the Court to Guyana's reply at paragraphs 2.102 to 2.110. But even if there were such a rule in 1897 quad non, what coercion is Venezuela talking about? How was it coerced into signing the 1897 treaty, and by whom? There is absolutely no evidence that Mr. Olney or President Cleveland or the United States coerced Venezuela in any way. The evidence is all to the contrary, particularly as Mr. Olney wrote to Justice Brewer. Both of Venezuela's representatives, Mr. Andrade and Mr. Storrow, were fully satisfied with the draft treaty that had been negotiated. In February 1897, in submitting the treaty to the Venezuelan Congress for ratification, President Crespo himself made clear that Venezuela was not coerced into signing the treaty. These are his words. "The settlement plan was presented to Venezuela for its consideration with no coercive intent and in full respect of the sovereignty and independence of the Republic." How can they say they were coerced? The official yearbook published by Venezuela's foreign ministry for 1897, declared that the final terms of the treaty demonstrated that, quote, the government has neither paused nor spared any effort in the task of safeguarding the territorial integrity of the Republic. And it included this statement by the foreign minister expressing gratitude to the United States for its support in the treaty negotiations. Allow me to express my conviction that the foundations of this treaty represent, on the part of the United States, a noble and eminent effort for the sake of continental peace. These terms alone will serve as an enduring reminder for Venezuela of the interest with which its powerful sister nation sought to reconcile it with the great British nation in a dispute lasting more than half a century, marked by bitter incidents and perilous situations. Faced with this contemporaneous documentary evidence, how can Venezuela, in the present case, possibly argue that it was coerced to accept the treaty? In fact, it fails to identify any acts of coercion against it or any persons or entities who might have perpetrated such acts. Instead, it complains of what it calls, quote, structural coercion. In Venezuela's telling, it found itself in a situation in which it had no choice but to accept arbitration of its territorial dispute with Great Britain, because the alternative would have been to subject itself to further British expansion, which it was powerless to stop. But in making this argument, Venezuela conveniently forgets or deliberately ignores the fact that it had been pleading for precisely this outcome, an arbitration agreement with Great Britain, for the better part of 2 decades, that it repeatedly beseeched the United States to come to its assistance and to press the British to accept arbitration of the territorial dispute. That under U.S. pressure, the British finally agreed, and that the treaty negotiated by the U.S. in close consultation with Venezuela's representatives was deemed by Venezuela to be acceptable and worthy of signature. Venezuela's very belated contention, 66 years after the fact, that it was coerced into signing the treaty, physically or structurally, has no factual support. It is completely contradicted by the evidence before you. The bottom line, Mr. President, is that Venezuela cannot come up with any basis, any legitimate basis whatsoever, for invalidating the 1897 treaty, or for invalidating the 1899 Arbitral Award on the basis of an allegedly invalid compromis. This afternoon, my colleagues will demonstrate convincingly that there are no other bases for invalidating the 1899 award or the international boundary that resulted from it, and that the award was and remains valid and binding on both Venezuela and Guyana. Mr. President, members of the Court, I thank you for your kind courtesy and patient attention. This concludes Guyana's submissions in this session. We wish you a pleasant lunch, and we look forward to resuming our submissions this afternoon.
I thank Mr. Reckler. This concludes this morning's sitting. The oral proceedings will resume this afternoon at 3 p.m. The sitting is closed.